改啊，那不已经过完了？
对啊，那不就两个？都没有人。就是啊。哦。准备跑步吗？跑步啦。哦，你已经跑过啊？哇塞，厉害！
I mean, I'm going to take this one to over there.
Given this
I want to start by thanking Trish Schrader and the Public Law Program for paying the expenses to have our wonderful speaker here today. I want to thank the student ACLU chaps, and especially Emily Ciccone, for all the hard work they did for arranging this. And it's a tremendous pleasure to introduce the speaker to you. I've heard it said that you don't need many heroes if you choose your heroes wisely. And Burt Neuborne is one of my heroes. He's certainly my role model for what I want to be as a teacher and a scholar and a lawyer. As a professor, he's been on the New York University Law faculty since 1974. He's long been one of the most popular and most revered teachers at the New York University Law School. He's a prolific scholar. My guess is that all of you in civil procedure and federal courts and other classes have read, among other things, he's written his famous article, The Myth of Purity, in 1977. He's also a very accomplished litigator. For a time, he was the legal director of the American Civil Liberties Union. He's now the legal director of the Brennan Center. He's argued a large number of cases in the Supreme Court and federal courts of appeals. And I won't take any more of his time other than to say how wonderful it is to have him here at Duke today.
Thank you, Ron. Thank you. It's a pleasure to be here. It's a pleasure to be in any room that I can share with you. We've worked together for so long. The grandiose title of my talk is The Role of Courts in Time of War. And if I knew what the answer to that was, I would be a very wealthy man. So I don't know what the answer to that is. And I want to explore some concerns about the judicial role in times of crisis, especially the judicial role in dealing with constitutional issues and with efforts to protect fundamental constitutional values in times of serious crisis. And I want to just posit two models of constitutional law for you in times of crisis. The first one is a model I cynically call the deck chair theory of constitutional law. Now, the deck chair theory of constitutional law says that the Constitution that is really a lovely and comfortable deck chair that we deploy in sunny weather, that we sit and we compliment ourselves on what a comfortable and lovely chair it is, and how much we enjoy sitting in the sun. But the moment it starts to rain, we fold it up and put it away. And that the major reason that the American Constitution has lasted for more than 200 years is that it's never gotten wet. That in times of crisis, we simply fold and put the Constitution away. That's the cynical model, and I'll talk a little bit about it. The more hopeful model, which I think is often ignored but shouldn't be, is the checking function. The fact that the courts should be and are often, even in times of crisis, the safety net, the net that holds the political branches, especially the popular hysteria that will be generated in any time of crisis when there is great fear, that American courts have not just play deck chair with the Constitution. Sometimes they've been remarkably courageous in the defense of values in times of crisis, and that there is this dual tradition. I want to talk to you a little bit as we go through the talk of how one chooses between the two traditions. In other words, what should happen in times of crisis? How should judges think about their responsibilities and what they're supposed to do? And does anything really change in a time of crisis? Let me quickly do the deck chair with you. It's the standard history. But it's something that lawyers and people who care about the Constitution shouldn't ignore. There is in our past a disturbing tendency for us to throw away significant values in times of crisis. The Alien and Sedition Acts, you start all the way back there. Hysteria about the French Revolution leads the Adams administration and Congress to take a series of steps in 1798 that just happened to also help in the 1800 elections. Pursuant to that, dozens of people are jailed, including the congressman from Vermont, Benjamin Franklin's grandson, Benjamin Franklin Bache, is jailed and dies in jail as a result of having published material critical of the Adams administration. And that's the ink on the First Amendment wasn't dry before the first collapse took place in the Alien and Sedition Acts. And there was no judicial response to it. After all, this is before Marbury versus Madison. So there was no judicial response to it. Indeed, some of the judges were cheerleaders in the process. They presided over trials and were as oppressive as you could imagine in trying to suppress free speech. And it wasn't until the good sense of the American people electing Jefferson in 1800, and Jefferson then pardoned everybody who had been punished under the Alien and Sedition Acts, and the acts were simply allowed to sunset in 1802. So that's the first time. But then if you take it forward into the Civil War, one of the unexplored things about the Civil War, not unknown, but really unexplored, is the degree to which dissent over the Civil War was suppressed by the transfer of it the argument is somewhere between 13,000 and 38,000 people were jailed during the Civil War by military authorities, basically, most of them, for simply being critical of the war. Speaking out against the war and arguing that it simply wasn't worth the cost in blood. And Lincoln, as you, I'm sure, know, suspended the writ of habeas corpus and used military administration of justice in a number of areas. It's yet another example of maybe justified. I'm not suggesting that in these times of crisis, every time we move isn't justified, but it is an example of how in times of crisis, the ordinary rules change dramatically. Then, if you want to move forward to the First World War, hundreds of people were jailed in the First World War for doing nothing more than criticizing the war very vigorously. And when you study con law and you read the opinions, the Schenck opinions and the opinions in 1919, you'll see that if you look to see what it is they said, you will be astonished at how that speech could lead to incarceration. But it was a frightening time, and people were sufficiently concerned about crisis to throw away a lot of the traditional values that operate in times of peace. Then the Palmer raids in the 1920s, hundreds of people deported in the early 1920s on nothing more than their opinions. Again, you look back and you can't figure out how and why we would behave that way. And of course, the paradigm for it, probably the worst example of injustice in American history, and the two would be Dred Scott, and then the second one has to be Korematsu, in which we upheld the incarceration, the preventive detention, the preventive incarceration of 120,000 persons of Japanese ancestry, 80,000 of whom were citizens, and not a single one of whom was ever charged with any act of disloyalty. and we put them in camps during the Second World War. Why? Because we were terrified. And the fear of just simply broke away all of the restraints that the Constitution is designed to protect. If you move forward in time, the McCarthy era, the desperate, and we now know overblown, but nevertheless real, fear that the Communist Party was engaged in some sort of systematic effort to overthrow the government in the United States, led to the jailing, deportation, and the serious interference and end of the jobs of thousands and thousands of people who had done nothing more than become party members or in some way evince significant sympathy for the party during the 1940s, when they were a formal ally, into the 1950s. Then if you go forward again into the Vietnam era, you have the spectacle of young men being jailed for burning their draft card under the preposterous argument that the burning of the draft card threatened the administration of the selective service system, that somehow you couldn't administer the selective service system if people burned their cards in protest. There's a single thread that runs through these cases. And the thing that runs through these cases is fear. In each of those situations, fear caused us to change the way we usually assess risk. In our system, and this is a basic element of our system, we make two risk assumptions. They're very different than the risk assumptions of an authoritarian system. In our system, we make two basic assumptions. We assume that just because an individual has done something, that act is not going to lead to something worse. So just because you're, for example, you give a speech, that speech is not going to cause, is not going to have a bad tendency to cause a harm that the government has the right to suppress. And so before the government can suppress A because it might lead to B, when it's individual behavior, we require overwhelming proof. Depends how you analyze it, whether you analyze it under the due process clause for reasonable doubt, or whether you use the traditional free speech analysis. Whatever it is, it's a risk allocation mechanism that says just because the government says that there's a risk something might happen is not a basis for punishing an individual. It has to be more than just the identification of risk. And we reverse it in a remarkable way when the government's at stake. When you're talking about what kind of power the government has, what we do is we say, no. If you have this kind of power, it's a risk that you're going to abuse it. And so when government is at stake, we take away power that might be abused. When individual behavior is at stake, we allow people to act until proof that there's an abuse and not just risk. And if you think about it, the inversion of those two risk allocation mechanisms, the best about the individual, the worst about the state, you put them together and you have the kind of breathing space that creates institutional space in a free society that essentially keeps the government at bay and creates a room for individual freedom, even in controversial areas. And if you needed a shorthand diagram for how free societies exist, they exist because of the reciprocal operation of those two risk allocation mechanisms. Authoritarian societies reverse the mechanisms. Authoritarian societies view individuals as potential risks. If you're a dissident, if you don't toe the line in an authoritarian society, they say, gee, that's bad, but it could lead to something even worse. And so they allow people to suppress behavior A because it might lead to behavior B. On the other hand, government power is viewed very charitably. The mere fact that government might abuse power, might abuse a system when there's no warrants, or might abuse a system where discretionary authority is given to the police to engage in all sorts of law enforcement activity. The argument in authoritarian societies is, well, we can trust the government to do the right thing. And this is necessary as a form of protecting our public safety. Now, when you take apart the legal systems of an authoritarian regime, what you see is that there's the risk allocation, which is the inverse of what we have in a free society. They assume the best about the government and the worst about the individual. And those two things operate reciprocally to literally stamp out the ability to have any kind of significant freedom. So if, for example, you took a look at the legal regimes, Nazi Germany, Soviet regime, Cuba, Singapore, and you ask yourself, what do they all have in common? They all have in common that approach to risk. Trust the government, mistrust the individual. Take a look at the regimes, regardless of what the Constitution says. Take a look at the regimes of Britain, the United States, Canada, France, modern Germany, and you have an inversion. The best about the individual, the worst about the government. And you want to remember that. I think it's terribly important to recall, because in times of crisis, I want to cycle back to what fear does. In times of crisis, we as a people, understandably, are told and feel, because being a New Yorker, and my office at the Brennan Center is just a few blocks from the World Trade Center. I was there when the towers went down. It was terrifying. It continues to be terrifying to live in a city in which you assume that there will be another attack someday. But you want to remember that there's a huge temptation in times of crisis to adopt the authoritarian risk allocation mechanism, to say things are so scary that what we better do is start treating people as though they're risks and the government as though it isn't. And you put the two things together, and that, in my opinion, explains what happens it's a way of explaining what's taken place in American history. In each of those settings, we threw away our usual risk allocation, and we adopted the risk allocation that says, mistrust the individual, trust the state. Put those two things together, and you have a prescription for three things. Three things. The exaggeration of the risk of future harm as a justification for current government policy. That's just what they said in Korematsu. The massive exaggeration of the risk of harm from Japanese became the justification for incarcerating them now. So the first real problem is that the government is essentially allowed, usually it's the executive, allowed to exaggerate the future risk in order to justify current repressive policies that are thought to minimize the risk. The second thing is the false positives. People will be convicted. People will be found guilty. People will be deported. People will be fired. People will have their lives disrupted because of a false positive finding, because of a finding that they are indeed a bad person, or indeed a risky person, or indeed a dangerous person, even though if you use the usual risk allocation mechanisms, they wouldn't be found that way. They would not be found guilty that way. And then the third is excessive sanctions, excessive harshness, excessive penalties, because we're so afraid. If you look into American history, what you will find is that in periods of crisis, each time we react badly, each time we throw away the values that we care about, it's because we inverted the risk mechanisms and essentially invited false positives, overregulation based on an inaccurate and exaggerated assessment of future risk, and excessive harshness in the way we dealt with the people that we thought were risks. Now, what does that say about today? I mean, I can tell you about history until the cows come home, but I'll tell you one thing about history. Fear trumps history. We can have this history talk over and over to us. But the truth of the matter is, if people are frightened enough, history goes out the window and we adopt the same risk allocation mechanisms. Those same notions that say, mistrust the individual, trust the state, and we'll go forward with a mechanism designed to deal with the risk. Well, we're confronting precisely that problem now. And I want to try to bring it home to the reality of current practice. And the current practice is this. I skipped over something, and I want to remind you that we don't always collapse. The American judiciary also has a proud tradition of protecting individual rights in time of crisis. Exparte Milligan, which is the case after the Civil War, which said that you cannot try civilian noncombatants before a military tribunal, before a military commission, even if the president wants to. And 5 members of the court in Ex parte Milligan said, even if Congress and the president, that there is simply no power in the United States to go from what is a protective tribunal in which rights are recognized to a much more risk-averse tribunal, a military commission, which is essentially designed to deal with high-risk situations. And before you take somebody out of a protective and put him into an unprotective, the Constitution has to be considered. And Ex parte Milligan said you just can't do it to a civilian non-combatant. Now, that was an important decision. It was a unanimous decision. 5 of them said you can't do it at all. 4 of them said you certainly can't do it without explicit congressional authorization. Then you move forward in time, and you have a case that sometimes gets forgotten. I mean, Barnett is a First Amendment case in the middle of the Second World War, in which the court reached deep and protected the basic fundamental notions of free speech, even during a war, which is one of the great traditions that we have. Lots of things get thrown away. Free speech doesn't, even in times of crisis. At least not it's occasionally weakened, but it's not thrown away. But the case I wanted to stress with you, the last one, is Ex parte Endo. This is a case that everybody forgets. Ex parte Endo was decided the same day as Korematsu by the Supreme Court. Korematsu upholds the Japanese internment and basically says that who are we to second guess the statements of the military that this is a sufficient risk that justifies the executive taking these steps. But Ex parte Endo says if the Japanese are going to be put into camps, then once they're there, and this is not enough, I mean, believe me, I'm not apologizing for the court or for Korematsu, but once they're there, then you must give them immediate hearings on whether, on an individualized basis, there is evidence to think that they are a risk. And if you can't justify that on the basis of individualized hearings, individualized due process hearings, then you must let them go. Now, Ex parte Endo is a statutory case. They construed the statutes creating the camps and said that's what Congress must have wanted because if Congress didn't put that in, it would make the statute unconstitutional. So that Ex parte Endo is a case decided the same day as Korematsu. Ex parte Endo ended the Japanese internments. The president had, once the president realized that hearings were necessary, the camps were closed and everybody was sent home. So that Ex parte Endo are the courts operating at what they should be doing, which is to provide some degree of safety net in times of crisis. So if we have these 2 traditions, if we have a tradition of Milligan, Ex parte Endo, Barnett, and a number of other cases where judges act courageously to protect values in times of crisis, and then we have a tradition where they collapse, where Korematsu, Dennis, Harasiadis versus Shaughnessy, which are cases in which, in terms of crisis, they simply collapse. What do we do today? How do we act today in response to what is a tremendous risk that we all know we face? It's absurd to suggest that terrorism is not a major risk to the United States. It's absurd to suggest that we all are not correctly and intensely concerned with maximizing national security and with trying to prevent another terrorist attack. And that cycles now to what I believe to be the issue we have before us. And that's this. We have every regime has special institutions to deal with high-risk situations. We have our ordinary courts, but in addition to the ordinary courts, there are military justice, there's courts martial, and then in addition to that, there's a special kind of military justice called military commissions, which are really a third thing for battlefield justice. I mean, if I had to roughly compartmentalize, the ordinary courts, the Article III courts, the ordinary courts are for ordinary days, for ordinary things. criminal prosecutions, the ordinary processes of justice. In those courts, in the Article III courts, we maintain the risk allocation. Think about it for a minute. We insist on guilt beyond a reasonable doubt. We insist on confrontation clause. We insist on jury trial. We insist on the prophylactic procedures against unlawful search and seizure and Miranda warnings. We do all the things that free societies do to protect the individual and to keep the state at a distance. We think the best about the individual, the worst about the state. It's the risk allocation I talked about. That allocation operates at the level of the ordinary courts. Then you move over to the courts martial, which is a military system designed to do a different kind of justice. Now, let me immediately say, the people who operate in that military system are equally committed to justice as the people who operate the Article III courts. But they have a different function. Security and efficiency is a much higher value in the military tribunals, and it should be, because you want the military tribunals to work in the most efficient way, so that you don't get the same level of individualized protection in the military tribunals as you would get in the Article III courts. Then you go one step further to the commissions. Military commissions come into being in the history of military law as battlefield operations. Sometimes it's necessary to have a hearing in the midst of a battle, or just afterwards, or while there's still a chance of a counterattack, or while combat operations are still going on. So not surprisingly, military commissions are the most national security conscious, the most efficient, where the risks are inverted, and inverted for a good reason. Because they're going on in a situation where nobody would think that you wanted to have an ordinary Article III proceeding. So the question is, we have three different places that we can put people. We can put them in the Article III courts, we can put them in the ordinary courts-martial situation, or we can put them in the military tribunals. And those three institutions, there is a possible fourth that many societies have. We don't. But there is a possible fourth, and that's a kind of watered-down version of your ordinary civilian. That's the English diploc courts, the French terrorism courts, the state of emergency courts in some places, which brings into being a new regime. We don't have that as a formal matter. Query whether we don't use it as an informal matter, but we don't have it as a formal matter. So here are the choices. If you're trying to make policy now, you got a choice between saying prosecute them in an Article III court, you got a choice between saying court-martial them, or you got a choice between saying put them into a drumhead proceeding, either a military commission or a quick status review commission, the kinds of things that happen on battlefields. Those three places all try to do justice. Every person who works in an Article III court that I know of, every lawyer and judge that I know of that operates in the military, in the court-martial or in the commissions, do so in good faith and in an effort to do justice as they see it. But what differs among those three proceedings is the way we deal with risk, how we allocate risk. The degree to which we are willing to allocate risk in favor of the individual and against the state, or, when you take it all the way over, in favor of the state and against the individual. And that changes the nature of those proceedings tremendously. It changes the nature of the justice that comes out of those proceedings tremendously. The question that we have to ask today is, who throws the switch to put people into what proceeding? And this is new. This is new in American law. The reason that it's new is that in the past, before we were dealing with terrorism, we've always had these three possible proceedings. We've always had the civilian courts, the military courts, and the special military courts for particularly high-risk situations like battlefield situations. We've always had them, but it's always been obvious where the person should go. Let's take three cases. Exparte Milligan, which is the Civil War case that I mentioned to you. It was conceded by everybody that Milligan, who, by the way, today would be called a terrorist, Milligan was engaged in a conspiracy to smuggle arms into southern Indiana in order to foment rebellion and to aid the Confederate cause in southern Indiana. But everybody concedes back in the mid-1860s, in 1867, that Milligan is a civilian non-combatant. So if you're a civilian non-combatant, everybody says, well, civilian non-combatants, they come color-coded to go into the Article III courts. And that's what the Supreme Court holds. The Supreme Court holds that when you show up as a civilian non-combatant, we know where you're supposed to go. You go into the Article III courts with all of the risk allocations going in favor of the individual and against the state. Now we move forward in time to a celebrated case during the Second World War, Exparte Quirin. Exparte Quirin in 1942 is a group of saboteurs, German saboteurs, landed off the coast of Long Island on a German submarine in full military uniform. They march off, they bury the uniforms, they put on civilian clothes, and they're landed in Long Island to engage in sabotage, to sabotage defense plants and to sabotage the war effort. They had all lived in the United States for a long period of time, spoke English perfectly, and they were landed to engage in sabotage. Well, they were truly the gang that couldn't shoot straight. They couldn't get anything right. They wound up surrendering. In a hilarious story, one of them went in and tried to surrender, and the FBI thought he was a hoax and threw him out. And it wasn't until he opened his suitcase and showed him that he had thousands of dollars in the suitcase that the FBI took him seriously. But they took them into custody and tried them before a military commission. And here's the fascinating thing: Roosevelt, for whatever reasons, in 1942. Half political, half the fact that the country was terrified, decided that this was a battlefield justice case. And so instead of court-martialing them, no one ever thought that there was any chance that they would go in for an Article III court, but instead of court-martialing them, he convened a military commission, tried them before a military commission, and they were executed a week later. Now, again, Exparte Quirin's an easy allocation case. These were German saboteurs landed by a German military vessel on American soil in the midst of a declared war. So of course they're high-risk individuals. You don't indulge in presumptions against harming the individual. You know who these guys are. You know what they want to do. You treat them as high-risk individuals, and either you deal with them in a court-martial or you deal with them through military commissions. So Roosevelt sent them to a military commission. One can argue about whether or not that was necessary after they had surrendered and whether a court-martial wouldn't have been a better place to do it. But whatever it is, they came dressed to kill. And you knew who they were, and you put them in the right place. Ex parte endo, the case I mentioned to you a moment ago, is the third allocation case. Since everybody conceded in ex parte endo that the petitioner was absolutely loyal, that there was no possibility of casting any doubt on her loyalty. And the only reason she was in the camp is that her skin was a different color. Everybody said, well, wait a minute, of course, that's a person that has to go into the civilian system. That's where we allocate risks against the government and in favor of the individual, and that's why the government has the burden of coming forward and proving that she's disloyal, or else they have to let her go. Well, those are the three major allocation cases, and you can see that if you look at them, they don't help us now. Because the crucial problem now is that we're dealing with people who, first of all, don't come dressed up in uniforms. Terrorists don't announce who they are. They blend into the population. They don't have allegiance to a foreign power. There's the objective criteria that in the past were used to move people from high-risk to low-risk tribunals across the spectrum don't exist today. And the question is, what do we do with somebody whom we've captured? And there are now many, many hundreds at Guantanamo Bay. Who knows how many more in other places. What do we do with people who we believe, or the executive believes, is in some way connected to terrorism? What kind of tribunal are they going to be tried in? What is going now? Let me say, I want to make it clear. I am not suggesting that the military commissions will act in bad faith. And I am not suggesting that the court-martials act in bad faith, and I'm certainly not suggesting that there's some intrinsic superiority of an Article III judge over a military lawyer. Indeed, everything we've learned from the last couple of years is the people that you really want to trust are the JAG lawyers who over and over and over again have tried to do the right thing here. But the question is a serious question of how we allocate people into that tribunal. We have three choices, and then there are three choices. We can unilaterally let the executive do it. That's the Bush administration position. The Bush administration position is that either as a matter of commander-in-chief, either because of Article 2, Section 2, the commander-in-chief of the Army and Navy, he has inherent power in a time of crisis like this to move people back and forth from one set of tribunals to the other. And he can decide, or his designees can decide, what kind of a hearing and what kind of justice people get. That's one possibility. The second possibility is we could use the courts. We could say, no, the courts throw the switch. The Article III courts throw the switch. There has to be some sort of hearing in an Article III court which will determine whether we've got an ordinary person who has to go through the ordinary courts or whether we've got a high-risk person that we can put into a military tribunal, either a court-martial or a military commission, or we can let Congress do it. Congress has to be the one to finally make the decision. One could debate this, but let me quickly say, I'll give you the Bush administration argument, which is a plausible argument. It's not a crazy argument. I just think it's wrong, but it's certainly not crazy. The Bush administration argument is this. Bush says, look, you guys, UACLU guys, you immediately admit that for years we've recognized that there is something called battlefield justice. You've recognized that we have three spheres of justice, I call them: civilian courts, courts-martial, military commissions. We have battlefield justice because we need it in certain situations. Nobody would suggest that you give a jury trial to an accused saboteur on a battlefield where you're trying to figure out what to do with him. He says, you concede that. He said, what you don't understand is that the world's changed. That we don't have traditional military operations anymore where people march around in uniforms with flags, and you know that if they are marching around with a uniform and a flag, you put them into the high-risk military stuff. But if they're civilians, you put them in the low-risk stuff. That's not happening anymore. What we have now is we have a worldwide struggle. He calls it a war. A worldwide struggle against terrorists. Who are engaged in horrible activities for ideological, non-rational ends, and who are willing to take large numbers of lives as a result of it. He said, I am the President of the United States. He said, I'm a battlefield commander. I'm just like a major on the beach at Normandy. I am conducting a war, a military operation, and as the President of the United States, whatever power you would give to that major, you would let that major use military commissions. You would let that major spy on the enemy. You would let that major do everything the major needed to do in order to win that combat skirmish on the beach at Normandy. He said, I'm the President of the United States. I'm engaged in exactly that. Only I'm engaged on it in a worldwide struggle with forces of terrorism, and I should have the same power that the major on the beach at Normandy had. And those are three things. I should have the power to be able to take people into custody, just like if you capture, if you're on the beach in Normandy and you capture one of the enemy soldiers. You take them into custody. You put them in preventive detention. That's what a prisoner of war camp is really all about. It's a massive preventive detention facility. Because if you let them go, you're afraid they'll come back and start shooting at you. So you put them in preventive detention until the end of the war. He said, I should be able to take anybody I want to into custody around the world and put them into indefinite military, or at least into preventive detention until the end of the war, just like a major could have done at Normandy. Secondly, I should be able, if I think that there are particularly egregious people among them who have done terrible things, I should be able to try those people, not in an Article III court, because that's too good for them. I should be able to try them in a military commission using battlefield justice, just the way the major could have tried somebody on the beach at Normandy. And finally, I should be allowed to eavesdrop and gather information without warrants and without any kind of constitutional protection, just like the major would have been able to send somebody behind enemy lines and listen. No one's going to say you got to have a warrant to do that. He has to do it in order to survive, in order to win in a war. And the president says those three things operate now. We're in a war. I'm the combat commander. The world is a large battlefield. We're engaged in a struggle with a shadowy enemy. I should be able to preventively detain anybody I think I should. I should be able to try anyone I should under the low risk battlefield justice. And I should be able to listen in to anybody I want to in order to get the intelligence I need to win the war. And if you put those three things together, you have a theory of unilateral executive action, which is what the Bush administration, I believe, has been functioning under for the last 5 years. Now recognize it is not incoherent. It is not incoherent to argue that that's what we have to do in order to survive today. I believe it is dangerous and wrong, but it's dangerous and wrong not because it's incoherent, but because it overlooks one huge message that our past tells us. And that's that when you allow the executive to operate unilaterally in a period of crisis, you will get the three things that I mentioned. You will get systematic overestimate of future risk as a justification for current depression. You will get systematically high numbers of false positives, innocent people being sanctioned. And you will get systematic harshness, excessive harshness in the treatment of people you catch. Now, the story of the last 5 years is that story. It's false positives, excessive harshness, an exaggeration of the risks. It is part of human nature that if you allow a small group of people committed in a crisis situation to make these judgments in a hermetically sealed way, you will get exactly what you can predict, which is exactly what's happened every single time we have given this power unilaterally to the president, which doesn't mean that the power shouldn't exist. I'm not suggesting in times of crisis that we have to say nothing's changed. The question is, who pulls the switch and for what? And for me, to give that to a small group of people who have a huge stake in exaggerating the risk and exaggerating the number of false positives and exaggerating the degree of sanctioning, is to invite exactly what we've got. So for me at least, unilateral executive action is a non-starter. We can do it, and we can back ourselves into it, but it's going to be another situation that when we come out the other end, we're going to look back and we're going to say, how could we have done this? How could we have put 120,000 Japanese into a concentration camp? We're going to come out again and we're going to look back and we're going to say, how could we have done this? And the reason is because we institutionally placed the decision-making in a small, hermetically sealed group of people who are almost certain under those circumstances to do exactly what the risks tell you. Excessive measurement of future risk, excessive current false positives, and excessively harsh sanctions. Now, so the second possibility are the courts. I grew up worshiping the courts. My kids claim that I don't have a real religion, I just worship Earl Warren. Which is probably right. I mean, that's as close as I have to worshiping anybody. But courts can't do this. Courts can't do this. If you ask courts in a national security situation to make assessments about risk in a setting in which they lack fact-finding capability, then you put them into a Korematsu situation where every member of that Supreme Court knew that DeWitt was lying. General DeWitt was the general on the West Coast that published these ridiculous reports of risk that caused them to be locked up. They all knew that there was a problem, but who could be sure? Who knows for sure? And if you're a judge and some military person or some CIA person or the president tells you that the risks are huge, what are you supposed to do? You don't have, I mean, the one thing the courts don't have is independent fact-finding power here. And that's why whenever we lean on them, if you're counting on courts to be the deus ex machina to pull us out of this process, We will fail every time. There will be the occasional heroic Barnett decision. There will be the occasional crafty Endo decision that figures out a way to snatch justice. But by and large, we will repeat the past. We will repeat the deck chair theory of constitutional justice because courts are institutionally incapable of doing what we would want them to do here, which is to make the real assessment of risk that's known before we throw the switch and move people out of the usual rights protective regimes into the security protective regimes of the court-martial and the military commissions. So that leaves the last group. It's Congress. And it seems to me that what we should be doing is thinking as lawyers and as people who care about institutional operation in our country, what we should be saying is what we want there to be a joint decision made by the President and Congress that decides when these things should take place and when they should not. Now, there will always be a role for the courts, as there was in Ex parte Milligan, to say, look, there are some things that even Congress and the President can't do. But at least as a first-line institutional case, it seems to me so clear that what we should be doing is saying we can't trust the executive to do it alone. The courts are noble and wonderful people, but they don't have the resources. They don't have the machine to do it. If anybody is going to do it, it has to be Congress. If they're going to perform the checking function that the separation of powers requires here, it has to be Congress. And it has to be, which means that we now have to deal, I think, with an issue that we never had to deal with before. And that is, how do we decide how we read congressional action? What constitutes congressional authorization and what doesn't? Does the authorization for the use of military force in Afghanistan provide implied power to the president to do everything he wants to under in this situation? What about silence? What about the passage of military appropriations? In other words, we need to think in a principled way of what counts as congressional authorization. And I'm going to end my little talk by suggesting to you that we have an answer in our history. The best part of the way the Supreme Court reacts to times of crisis is not its protection of individual rights. It's not been terribly good at that. And it's not to try to do something unilateral or to give things away to the president. The best thing that the courts have done is to say to Congress, think about it. If you want to throw the switch, if you want people tried in military commissions, if you want people tried in court-martials, if you want them moved out of the usual avenues of justice, tell us. But tell us explicitly and clearly after considering it so that we know that you've made a decision. And in the history of the United States, my research has not found a single case in which the courts have rejected a combined request from the executive and the legislature to throw the switch, to move into a more protective regime. Because if both political branches say it's necessary, it takes a huge amount of judicial action and really almost pride to say, well, we know better. But the important thing is to make sure that it really is a joint presidential congressional determination. And that the things that pass for authorization have got to be simply turned down. Now, I'm going to give you a couple of cases and then we'll break. And the couple of cases are this. If you look into the history, and I'm immensely indebted to Curtis Bradley and Jack Goldsmith for this. They did a superb law review article in 118 Harvard Law Review. And those of you who are interested in this area, this is where you start. You start with the Bradley and Goldsmith article in 118 Harvard. You go back into our history, and you take a look at the courts grappling with this. And what you find is something called the Doctrine of Clear Statement. The Doctrine of Clear Statement says to Congress, it's your call. It's your call. But you have to tell us what your call is. You can't let us try to figure it out from some sort of ambiguous situation, because politicians will always try to hide behind silence and to hide behind ambiguity so they don't have to take political responsibility for their judgments. But the important thing is to force them to take political responsibility for the judgment by making the judgment openly and absolutely clearly, so that the people can then vote on whether they agree with that. So it can't be put unilaterally into the president. It shouldn't be put unilaterally into the courts. It's a bilateral judgment made by the president and the legislature, with the courts playing the role of saying, I want to make sure that the legislature actually agrees. And if you look at cases beginning with the construction of the Non-Intercourse Act, which was the embargo, the French embargo. The leading one is Charming Betsy. And you take it all the way through. You look at the way they read the statute in Ex parte Endo. You look at the way that they read the statute about civilians being tried by military authorities in Hawaii shortly after the cessation of hostilities. You look at the way they construed the statute in New York Times in the Pentagon Papers case to see whether there was authorization to seek the injunction. You over and over and over again. Most importantly, you look to see how they construed the authorization for the use of military force in the War of 1812, believe it or not. Because John Marshall wrote two great opinions here, which I think give us the way. His first one was to construe the Non-Intercourse Acts very narrowly, because he said, if Congress wants this to happen, they better tell me. And I don't see enough of a construction. But most importantly, they took the authorization for the use of military force in 1812 and the Declaration Against War of Britain in 1812. And they said the combined effect of those two documents did not authorize the president to seize the property of resident enemy aliens in the United States, despite the fact that international law says you can do so. You can seize the property of enemy aliens during a war. But Marshall said, I'm not going to say that we've authorized that unless Congress explicitly tells me that's what they want. If Congress says, throw the switch and move people into military commissions, then we'll have to ask whether or not the military commissions satisfy basic fairness that the Due Process Clause requires. But we will not be asking the question we're asking now, and that is, where is the president's authorization to insist that military commissions be the place to try these cases? He points to his unilateral power as the commander-in-chief, and basically to the authorization for the use of force in Afghanistan, and the fact that the Uniform Code of Military Justice authorizes military commissions. Well, we're going to have an answer to the question before the end of the year. And the question, I predict, the court will pass on this in the Hamden case that was argued last week. Because that's a case in which Hamden, who's alleged to be Osama bin Laden's driver, was captured on the battlefield and has been in Guantanamo Bay now for 4 years. And they've now going to try him before a military commission of 7 officers, one of whom has legal training, where hearsay will be admissible, where he doesn't have to be physically present at all times if sensitive information is being discussed, where, at least under the existing rules, evidence from torture is admissible under certain circumstances. And that's going to be the hearing that he's going to get. And the question is, does the president have the power under these circumstances to take somebody and put him into that kind of hearing? I don't want to say that it can never happen, because I'm not sure, because crisis does require survival, and survival does require compromise. But if we are going to do something like that, it can't be the unilateral judgment of the president. It must be only because the president and the Congress, acting jointly, have made a decision that is necessary and have told us why, have made it part of the political discussion and political process, and allowed the courts to review whether it is minimally acceptable. And so my suggestion to you is that's where I hope we'll go. I hope we won't go through a process of somebody saying nothing's changed. Something's changed. We're not in the world that existed before 9/11. Something's changed. The risks are higher, and we have to react to it. But it's equally true that we haven't thrown everything out. And the president doesn't have unilateral determination to decide how much of the Constitution is left. What we need is sober, careful behavior by the two political branches, operating under the scrutiny of the courts to make sure that there is a constitutional minimum in any of the procedures that are being used, but most importantly, making sure that Congress has expressed themselves and expressed themselves vigorously and clearly on the issue. Thank you. Got a couple more minutes for questions, so feel free. Yeah?
Wouldn't a fourth option be to just find new objective criteria so that it becomes obvious again where people belong?
That's a great question. The suggestion was, in the old days, we could use military uniforms and allegiance to a foreign power. Shouldn't it be possible to be able to develop objective criteria now that will identify the high-risk people? If it were possible to do that, I mean, if there were a litmus test that we could develop, that would be great. The trouble is, they look like us. They're living in our communities. I mean, they don't advertise themselves as terrorists. And so if it were possible to have that kind of objective criteria, it would make everybody's life a lot easier. My prediction is that it's going to be very hard to work it out, but it's a great question.
So you got 3 votes today to grant cert to Padilha. And so I'm guessing you're going to get 3 votes to say that the president unilaterally can't move back and forth among your 3 categories. But there weren't 4.
Oh yeah, but don't forget two of the 3. The 3 votes. In case you hadn't heard, they denied cert in Padilha this morning. Padilha is the guy that was held for 4 years in detention at Guantanamo Bay, and then just before his case was going to be heard by the Supreme Court, the United States indicted him and shifted him over to a civilian court. He's being held in Florida now on a conspiracy count having nothing to do with why he was held at Guantanamo Bay. The conspiracy count argues that it had something to do with a conspiracy to commit terrorism in Europe. He was held in Guantanamo Bay because he was supposed to be the dirty bomber that was going to set off nuclear stuff in Chicago, and that turns out not to have been so, or at least it turns out not to be provable. But the votes this morning, and the government argued, deny cert because he's challenging his military commitment, his military detention. He's not in the detention of the military anymore. We've shifted him over to the civilian. That's what he's wanted. He wanted a trial in a civilian court. He's getting it. So why are we still hearing this case? 3 members of the court, Ginsburg, Breyer, and Souter. Ginsburg, Breyer, and Souter said, look, this is not moot. Shifting him over there doesn't mean anything because they can always move him back. And they haven't promised they aren't going to move him back, so it's not moot. 3 members of the court, Stevens, Kennedy, and the Chief Justice, concurred and explained that they were voting not because they thought it was moot, but because they thought, as a matter of discretionary use of certiorari power, an issue of this magnitude shouldn't be heard unless it's absolutely necessary. So if they try to move him back, they'll hear it. But if they don't try to move him back, they won't. The key in counting the numbers is that I count 5 in favor. My prediction is Hamden is 5-3 in favor of the position I just argued, and that Stevens and Kennedy join the Ginsburg, Souter, and Ginsburg, Souter, and Breyer. And if I'm worried about any vote, it's Breyer's vote. But I think Roberts, by the way, as you know, Roberts has recused himself. So it's an 8-person court that's going to hear Hamden. And my prediction is that it'll be at least 5-3, saying, 1, the president doesn't have unilateral power, and 2, the authorization for the use of military force in Afghanistan is not a sufficiently clear expression of congressional will to justify putting him into this type of tribunal. But then I'll come back next year and you can grade me.
I guess my question to you, I've also read Professor Bradley's article, Professor Bradley, is that...
Let the record indicate, I didn't see him.
I guess my question to you comes about, how you feel this clear statement requirement should apply in Hamden is did not seem to require a clear statement in Quirin. I mean, that was very kind of broad and I felt somewhat iffy statutory language, and this seems to be yet another, I mean, it's yet another, I mean, I know you have the military uniform and all that, but still it was a decision made by the executive based on somewhat vague and broad statutory authority in a time of war.
Well, of course, the time of war is important. Don't forget, you had a formal declaration of war in Quirin. You had a formal authorization for the use of military force in Quirin against Germany. You had the formal landing of somebody from a German submarine wearing German uniforms. Under those circumstances, it seems to me that they're so clearly enemy combatants that they automatically go into the high-risk category. And under those circumstances, the degree of congressional authorization was relatively unimportant because it was so clear that that's where they were going to fall. Quirin would have been much harder if it had been an American civilian who didn't have the kind of contacts with the German military that made the case relatively easy. And the guy said, I don't know, you got the wrong person. Now, under those circumstances, whether there was enough congressional authorization to take somebody off the streets and put him into a military commission, I would think the Quirin court would have gone the other way on that. That there just wasn't enough congressional authorization to take a disputed case and put it into the military commission. But they never disputed the authority of the military commission over them. They just said, well, of course, they argued that they should be tried in a court-martial. But it was clear that they were subject to trial. The real question there is whether battlefield justice, as opposed to court-martial justice, was the best choice. One more? Okay.
245 flight, the cab's downstairs at 1:15, so probably today with this plane.